right, everyone, welcome to another edition of the legal series here on the Income Statement TV. I'm excited to have Todd Jarvis back. We're actually going to do an impromptu bonus section today because we really want to start talking about intellectual property in today's age with social media and how people can start owning their own personal brands. We thought this might be really important with how everything is going on right now with COVID and people going on to online. So Todd, tell us a little bit about why protecting our own intellectual property is important and what is considered intellectual property.
Okay, great question. So first, the importance, right? So the importance is obviously your IP. It's, for the most part, it's what you have to offer. It's what sets you apart from your competitors, right? It's your message. It's your image. It's your it's the your website. It's all of that, right? It's who you are and what sets you apart and what helps people distinguish your work from everybody else's work. All right. So protecting that is imperative. I mean, that's one thing that kind of even stops or hinders people when they're trying to get in business is they have these great ideas, but they're afraid to let anybody know about them or to go into business with them because they're afraid that they're just going to be stolen and taken, and they can't keep control of it and keep it reined in and harness it for their own good. So luckily there are some doctrines in place, some protection in place to help you to protect these things. And it's also important on the other side to understand these things so that you don't accidentally or on purpose infringe on somebody else's rights. Okay, so we all want to be playing fair. We want everybody to play fair with us, so we want to make sure we're playing fair with them, right? I think that the age of we talked about this maybe a little bit last time with agreements, and we'll talk about it again, I'm sure, as we talk about other agreements in the next episodes. Really, with your business, you want win-win relationships. Okay, we want to make sure that everybody that you're engaging and working with, that those relationships are kind of win-win, and we're not just trying to get over on someone, because a lot of times that just doesn't work. So anyways, jumping into this, there's topically with IP, what is IP and how can you protect it? So intellectual property is just that. It's property that's like not, in a lot of cases, it's not physical, right? You can't necessarily put boundaries around it like you can real estate. So it's personal property. I mean, so anyways, let's just jump into the four types, all right? So the four types we're going to talk about today, and we'll talk about in this order. We're going to talk about copyrights, we're talking about trademarks, we're talking about trade secrets, and then we're talking about patents, okay? Those are the four basic types of intellectual property that exist here in the U.S., and that's something important to remember. Anytime we're talking about these things, we're talking about protecting these things within the boundaries of the United States. You can extend past that. We do have treaties with other countries and that you can take advantage of to extend your protection into those countries. If you are looking into marketing and providing services globally, you'll want to talk to someone about how to take care of those and to take advantage of those treaties to make it as easy as possible to protect your property in those countries, okay? And because there's a lot of these things, there's timing issues, all right? Especially when it comes to patents, there's a lot of timing things that can really cut you off. Trademarks is kind of the same way too. You got to be really aware of when deadlines are coming up and occurring so that you don't accidentally lose control or the ability to rely on the protection, okay? So copyrights in general, basically these are in place, copyrights are in place to protect, original works. Oftentimes we think about authorships like books, news articles, things like that, right? So, but we also have, there's literary, there's dramatic, so theater, there's musical, there's artistic, and other intellectual works. It doesn't protect the idea that's expressed through that authorship. It protects the authorship itself. It creates the protects the creativity and the newness and uniqueness and the display of that of the work, right? So to explain that and kind of really to help, I think the one place I think is like cookbooks. I think this is a great way to understand copyrights and how it's protecting the production and not necessarily and the creativity and not necessarily the information. So you can't really protect the recipe itself. The recipe is just a list of items and ideas and a method of doing something, right? That's not copyrightable. What is copyrightable is the presentation of the book, the notes that you write in there, your expression of your thoughts around the dish and how to incorporate it into a meal, or how it affects, how it played a part into your family's history or something like that, right? That's what's copyrightable. It's that artistic expression of that surrounding and the outlay of the book, not necessarily the recipe itself. Those recipes aren't protected. It's just an idea. It's just a list of information, right? Data points and a method of operation. So that's kind of what copyrights are. That's why most people think correctly when they think about copyrights. Things come to mind like books, photographs, and websites. When we're talking about online social media, your blog posts, your social media posts, all of those things are protected by the copyright doctrine. Now, when and how do you enlist the protection, or how do you make sure it's on your side and it's working? Well, what's nice about it is copyright is a right that springs into being as soon as the item or article is created. So as soon as you sculpt something, that sculpture, it's put into a tactile form, it is now protected through copyright. You don't have to register the sculpture with the US Copyright Office. Now you can, and it affords you some benefits for doing so, but you don't have to in order to rely on the protection, okay? As soon as you write a blog article and you post it, and it's out there for people to read, it's protected, it's yours, you have rights to protect that, okay? As soon as you take a photograph, again, that photograph is protected. Now, you don't have a right to whatever it is you photographed, right? And you can't stop someone else from photographing the same object and posting that, or same building or same person, right? But you do have the right to the specific photograph that you took and its source. Before it was film, negatives, and such. Now we're talking, digital files and things like that. So let's talk a little bit about what the copyright is. What rights does it give you, and such. So the rights that it's giving you, they're exclusive rights. It means they're exclusive to the person who created the work. And those rights are to reproduce the work, to make copies of it, basically, including electronic copies. So that's why people kind of got in trouble as the whole Napster thing, right? and music copying. They're reproducing a digital file that is now, that is a reproduction of work. We've got create adaptations. So basically, for instance, someone had, I heard this story in law school. I've never validated it, but I'm going to go ahead and tell it here because it's a good story. And if it doesn't work, it still articulate. If it's not true, it still articulates the point. So I think it was, so remember the Rocky movies, right? I can't remember which one it was. It might've been Rocky IV. I don't know. Anyways, at some point, someone had written a script and they submitted it saying, hey, this is a great idea for a Rocky movie. They sent it off to the production company and Sylvester Stallone's production company and whoever would be involved in that. And they said, let's do this. You can buy this, basically trying to sell them this idea for a sequel to one of the Rocky movies, or the Rocky movies that were out. And so they came back and said, I don't know if they ever responded to the person or not, or they just said, no, we're not going to pay you for this. And they went ahead and made the movie. Basically, the next sequel was strongly related to this script that had been sent to them. The person sued them, and basically it came down to the producers and the studio won, because that work, that script that was written by that person who was independent of the studio and anybody involved with the movies, had made a derivative work. And it's an adaptation of an already protected piece of work. And therefore, they didn't own the rights. The other person owned the rights. The production studio or whoever was making the movies owned the rights. Again, I'm not sure if that's a true story, but it would work that way. All right. So adaptations, based on, on the current work, sequels to books, sequels to movies, additional, the next volume of your cookbook, the next, different next thing in your series of videos, things like that, right? Adaptations. Maybe you're taking a play and make it into a movie, and then you're going to write a book based on it. Kind of usually goes the other way around, but that's okay. You're seeing what I'm saying, right? It could be in a different form, but it's a derivative work. It's an adaptation of that. Okay, and also you have the exclusive right to distribute copies of the work for sale or for rental. No one else can sell your work. No one else can rent your work, and such. So for commercial purposes, basically, right?
So I have a quick question.
Yeah.
2 examples, and maybe you can give, because I do work with a lot of photographers and other coaches, and some of the fear with like photographers and coaches is someone using their work. So for example, photographer might have this session and it's all business or like related. So they're taking pictures of the products and stuff like that. But then that person's using those photos not to promote their own business, per saying like, oh, they do graphic design or like social media, but they're using the photos that they purchased from you as the photographer, but they're not using it in the original form that it was meant for. How could a photographer protect themselves in that sense? And then I'll ask about the other example in a second.
Okay. No, great question. So these are rights that are afforded to you. However, they are self-regulated rights, meaning that you have self-enforcing rights. You have to enforce the right yourself. You have the exclusive right to use your photograph for whatever purposes, and to license others or assign others the right to use your work. So that's really what it comes down to. First step you need to do is make sure you have a clear agreement with the person who's hiring you. Okay, because here's the deal. Think about this. This goes both ways. So you have to, as a business owner, you need to think about this both ways. If you're the creator, when you create something like a photograph, here's as the example, you own that photograph and its source, right? No one else has a right to use it, even if they paid you to create it. So someone hired you to film, the food at the restaurant or something, right? You own the right to that image. The owner of the restaurant does not, even though it's called work for hire, right? You own it. You have all the rights. Now you can grant some of those rights or all of those rights to the person who is hiring you to produce them. So that's where it's important that your agreement with the person who's hiring you, engaging you to take these photographs, or you want to make sure that it's clear in the agreement what rights you're giving to them, how they can use, and how they are able to use, and in what situations and what capacity are they allowed to use your photographs. Are they allowed to resell them as stock photographs? Are they allowed to display them on their website just for advertising purposes? What rights are you giving them? Are you and this is the type of agreement we're talking about here is a licensing agreement. Okay, you're licensing them. You're giving them a license to use your product or to use, which here's your photograph. Now, there's also another agreement you can make, which is an assignment. The difference is that a license is kind of an ongoing agreement where they might be paying you to use your photograph, and then once they stop paying you, they can no longer use it. An assignment you can think of as, or a license is more restrictive. An assignment is more like you're handing it to them and you're kind of stepping away, and they're kind of taking it, and they own some of those rights. They're not just given the right to use it, okay? They actually own some of the rights. Now, it doesn't mean you have to assign them all the rights, but you have to choose that. You have to make the decision. What rights do you want to give to them? Are you giving them the right just to reproduce the work for marketing purposes? Are you giving them right to make adaptations? Are you giving them right to distribute copies? Think about those 3 different kinds of rights and the nuances within each of them on what you want to grant them, and make sure that you both understand the expectations there on each side of the assignment or the license that you're entering into with them, okay? Now, the flip side is that if you're hiring someone to create something for you, such as a logo for your business, you're hiring a digital artist or whatever they might call themselves to create a logo for your business, then you'll want to make sure as the business owner that you are getting as much, if not all of the rights to that work. It's your logo. You want to be able to use it however you want within your business, okay? You don't want to be caught finding out that this person pulls the rug out from under you, says you can no longer use this logo because I don't want you to, for whatever reason. So another place where that really comes up is with a website, because a website is a huge investment, right? You hire someone, maybe couple $1,000 to produce a website. I had a friend who paid $25,000 for this website. All right, it was fully interactive. It had a bunch of integrations and things like this, right? And it was a big hub for their business. And it came in hard times, so they wanted to change some things. So they were going to move this website to a new host and kind of try to run it themselves, And when they went to this person, who happened to be a friend, by the way, and that's why the agreements weren't really entered into, and they didn't take it too seriously because, they're my friend, we can do this casually. Well, that friend, that producer, that web designer said, no, you can't take this anywhere. This is mine. I own it. I was letting you use it. I gave it to you. I was letting your business use it and license it from me for the purposes that we designed it, but you don't own it. You can't take it anywhere. So when you hire someone to produce a work for you, like a website, logo, any of these things, make sure that you are getting the rights that you need to be able to do whatever your purposes are for that product. Because inherently and by default, the producer owns them, right? The artist owns them.
I think that's good to know, because a lot of people don't know these things and what the difference is. And when you go to someone, you're like, I'm getting a logo and they're designing it for me. It's mine. But hearing this, that some people might be going back to their persons like, so what rights do I have for this?
Right.
So the other example I have, and I've seen it frequently, I haven't experienced it myself, but once you start getting bigger, it happens. A lot of fear of coaches, like their signature courses or programs, they have people come in, do market research, but literally copy what they're doing and try to sell it and pass it off as their own. One, how can they protect themselves that way? And 2, what kind of course of action can they do to, I don't know what the right word is, but go after that person to stop them from using their property?
Okay, so it's really hard once you start selling something to maintain total control over it, right? So yeah, you can have like membership sites where people have to log in to the site to get access to the coursework and to go through that to watch your videos and get access to the worksheets or whatever it is you're doing with them. However, it's practically impossible to stop someone from copying those and distributing those, especially if they're a competitor and they're just buying your work to try to learn something from you, and then instead of just learning and taking some of the ideas that can be, anyways, learning from it and growing their own product. So really what it comes down to, if someone's doing that, the only recourse you have is to enforce these copyright laws, which would mean litigation. Okay, so it would mean hiring attorney. Well, basically the first step would be like a cease and desist. Like, hey, you're infringing on this. Let's stop, or I am going to step it up. Right? If they don't stop, then at that point you want to consult with a litigation trial attorney who's very competent with copyright law and copyright litigation, so they can do an analysis of your case and guide you in the right way to protecting those things. Like I said, there are no copyright laws, copyright police out there, and none of these things we're talking about today are regulated or policed by the government. Even though the government's affording you the right, it's up to you to enforce the rights, okay, on each of these things. So you have to take it in your own hands to enforce the right against someone who's possibly infringing on you. And ways to make sure you don't infringe on someone else's copyright. A big place where this happens is with photography. I just want to mention, especially with social media, because that's kind of the topic we're talking about today. Context, kind of big context we're talking about these situations in today is when you need artwork for a blog post or for a social media post or something, make sure you aren't using somebody else's work, that you aren't infringing on somebody else's copyright by taking their photograph and using it for your own business commercial needs. Okay, so the easiest way to do this, the easiest way to accidentally infringe on somebody else's copyright is to Google image search, and then right click, save image as, right? So as soon as you download an image from Google image search, there is a high likelihood that that image is copyrighted. Just because it shows up in a Google image search doesn't mean it's in the public domain. All right. Just means a web crawler's found it and is showing and thinks it's similar to what you're looking at or looking for. So you don't know if someone else has, and there really usually isn't a way to know whether that item, that image is copyrighted. So just don't do it. Go to Pixabay or go to Unsplash or something, right? Where you can get a licensed piece of art. Even the free. So a lot of times they're not free. Those ones I mentioned, you can get free stuff. They're just Creative Commons licenses or some other shareable license that gives you the right to use it commercially. So you don't have to pay for stock. You can find free sources. Just make sure that it's a source that is giving you the proper license to use that image commercially. All right. So don't use Google image searches to find your blog post images, because you are likely going to get and you just don't want that letter, right?
So I have a question. Sometimes people like to repost other people's pictures, and sometimes you don't know what the original post is. Is accrediting where you, like the account that you got the picture from, good enough?
It depends. I wouldn't, if Facebook automatically, if you're just sharing it if they put a shareable link on their article, I think you can feel comfortable using that, but I wouldn't go out of my way to, put a link to their blog article, and if it doesn't pull over the image, just download the image and stick it on there. I wouldn't do that. I'd recommend just linking to it and using your own image that is similar. But I mean, if Facebook automatically pulls it and you use the Facebook shareable link from their website, they need to take ownership of the fact of what they're allowing you to do by clicking on a link they provided you.
I was thinking more of like on Instagram, there's not really a share button except in stories. Right. But if you were like I got this from, I'm going to say Bubba Gump's, but you put on like original picture from Bubba Gump's account and drive them back there. Or let's say there's—
It might not be enough because it might not be enough because you're still using it to promote your own business. So best thing to do would be to reach out to Bubba Gump and say, hey, I love this thing. Can I put it on my own? I'll link it back to you. It'll be a win-win for both of us. See what they say.
Most times, often people just like that you're attributing it to them and being able to drive traffic. But
but I would do that. I would do that email or that message, and then copy the message and save it away. So if that Bubba Gump ever gets mad at you, you can say, no, you gave me permission.
Perfect.
So yeah, that's kind of how I'd handle that. Other things with copyrights, you can register copyrights. So, especially like a book or a sculpture, anything, blog posts, you probably aren't going to be registering. But software, big productions, you can register those. Curriculums would be a good thing to register. So if you've written out a curriculum for your business mentorship and your coaching program, I would recommend looking into registering that. It really isn't. It's pretty darn affordable. And what it does is it creates public notice, puts the whole nation on notice that you have created this and that it belongs to you and you own all the exclusive rights to it. And also, it does allow you, if you do need to get into litigation, it doesn't entitle you to greater damages. So you can get, attorney's fees and triple the damages, things like that, right? So it enables you to greater recourse. You get more out of a lawsuit by doing that rather than just relying on the standard copyright that comes into being when you created the course.
How long does the process take to get approved?
It's not long for a copyright. Okay. It just depends on how busy they are at the time, but a couple weeks. Oh, it's not like trademarks or patents, which we'll talk about in a little bit.
Okay.
It's a lot faster because they're not curating it, right? They're just basically taking it and registering it, making sure that it kind of falls in with one. It really makes sense that it should be copyrighted. And then beyond that, they're like, you're good to go type of a situation.
Okay.
Where with trademarks and patents, they are curating it and there are specific things that need to be taken care of. So we'll talk about that in a second, but other questions and things that we need to touch on with, a lot of times people ask, well, how are digital files or digital images, how are all those considered copyrighted? Because you'll see in the copyright rules and laws, they always talk about like being affixed to a tangible medium, right? They use that term all the time. And so the tangible medium they use when to apply this digital is that they're talking about it stored on computer memory. So it's on somewhere on some server, it's sitting in computer memory on a physical drive somewhere.
Okay.
So it's kind of how that works if people have that question. And the length of a copyright, it's usually the life of the author plus 70 years in general. So 70 years past the death of the person who created it is generally what you're looking at.
Can a family member, like let's say they're taking over the business, and can they take over the copyright of the curriculum?
Yeah, you can assign it,
Okay.
right? You can assign. So if you create a curriculum and you want your business to own it rather than you own it individually, you can assign your copyright, these exclusive rights to the business. So you no longer own them personally. Now the business owns them, and whoever's running the business can manage them and such. So I mean that's one thing that people can bring into a business. Like like partners are coming together. One guy's the money guy, the other guy's the idea guy. So the idea guy is creating the curriculum and assigning it or licensing it to the business, assigning it to the business, and that's their contribution. And the other person's bringing the hard cash, right, contribution. So different ways that IP is a physical asset. I mean, not physical assets, it's intellectual property. It's an asset that has value and should be considered such. So make sure you're getting credit for that if you're creating these things and you have partners. So
it's just me, but some people might. So
yeah.
I wanted to throw that out there.
Yep. Okay. Should we transition to trademarks then?
Yeah, because I want to know the difference.
Okay. So trademarks are quite a bit different than a copyright. I know they get confused a lot, right? So a trademark is where you see, someone puts their logo up or a slogan up, and you'll see the little TM mark, or you'll see the circle R mark, right? So those are both ways to claim a trademark as yours. So I highly recommend, again, just like copyrights, trademarks spring into being as soon as you create the mark, all right? They actually come into being and enforceable when you create the mark and use it in commerce. So if you've created a logo, for instance, or a company name, but you haven't started engaging clients or haven't started reaching out to the public in a way that would be considered using it in commerce, then you don't have any trademark rights in it yet. As soon as you start using it in commerce, you put it on an Etsy page to sell some goods, or you put it on your website, and you have a way on your website for people to hire you and engage with you as a business owner. Then that's when the trademark becomes enforceable. Okay, not before then. So it can be, words, a name, a symbol, color, sounds, other devices. So a combination of all these things. You can trademark any of those things. And basically the point of a trademark is to indicate the source, the origin of a good or service, okay? It distinguishes it from the goods and services of other competitors, all right? So what a trademark is all about, it's all about customer confusion, all right? It's trying to say, you can tell what, you can tell this item this shoe is a Nike shoe because it has Nike's emblem on it, has their name on it. You can see their trademarks on it. And you can trust now that this shoe is up to the quality that Nike requires, whatever quality that might be. Everybody has their opinions of their shoes, but it should meet the requirements and the expectations a consumer would have with a Nike product. Okay, you're pouring your heart and soul into your business. Yeah. This is all your goodwill. It's all your efforts. It's your blood, sweat, and tears. Your money. You want to be able to protect that and identify it, so people can trust what you're producing and trust that when they buy something with your slogan on it or your logo on it, your name on it, that they're getting the quality they can normally expect from you. And that's why you have protection here, okay? Because you don't want someone else to be able to throw your name on a product and try to sell it to someone, and that person because that person's going to expect the quality they would normally associate with your product. Yeah. But then all of a sudden that person's product isn't that good. Now your name is being diluted and people are upset. So it's really to protect that, right? It's to protect, it's to help you create a brand and create an expectation with your customers and help them not be confused with other people's goods and services that are similar to yours, but not up to your specifications or your quality.
I like it.
Yeah. So what you have the right to do under a trademark, it's actually exclusive. It's an exclusionary right, kind of like patents are an exclusionary right, where a copyright is, it gives you a right to do something, reproduce, sell, make copies, make adaptations of a product or a good or creative work. A trademark doesn't give you the right to do anything. It gives you the right to stop people from doing things. Okay, it's an exclusionary right. You're excluding others from using your trademarks on similar goods and services. All right, so there's an important key there: similar goods and services. So yeah, we have, you might have a name of a product and you sell business courses to business owners to help them to take the next step in their business and to grow and to prosper, right? You might have that kind of a consulting business, and you have some name for that business, right? Well, someone else could use that same name in a different industry, all right? You can't stop someone from using the same name in a goods or service market that you're not currently in or not likely to grow into, okay? So I hope that kind of makes sense a little bit there. When you register a trademark or when you're claiming a trademark, you're claiming it for that goods and services. That's why you might see, trying to think of something that, like a Roadrunner this or a Roadrunner that,
Yeah.
like Roadrunner, used books, but then you might have a Roadrunner HVAC service. Okay, they're not infringing on each other's trademarks by having a picture of a Roadrunner as their logo, because no one's going to be confused that the HVAC guy, isn't selling books, or vice versa, right?
Yeah.
So it is industry specific, and there is kind of there's like blurred lines there as far as one that you're protected within the industry that you are currently working in, and any similar that there's a likelihood that you would expand into. Okay.
Okay.
Like Nike shoes and Nike, expanding into socks isn't that far of a stretch, right? So that's kind of an idea there as far as you're protecting what you're currently in and what you're likely to expand your business into immediately or in the future. So yeah. So if you see someone else with, yeah.
No, go ahead, finish.
No, I was just going to reiterate that point. It's fine. Go ahead.
Oh, no. Okay, so I have a question. And this might be a completely different question, but let's say you are a local business, we'll say a cafe, and you're called the Runner Cafe or something. No, they actually have one of those. Runner Restaurant. But then you start to expand outside of your city and then outside of your state. You never expected to grow, but let's say you grow. But there might be a bunch of other Roadrunner restaurants in other cities and states. How do you kind of grow unexpected like that to be known nationwide and not infringe on somebody else's trademark or start to trademark it?
Okay, great question. Now this really comes into planning up front. This is a big investment, starting a business, and one of the things you really need to consider and really do a good job of is figuring out your branding, figuring out your name, and making sure that it's a protectable name. Okay, so let's talk about what that means, and it has a lot to do with what you're asking here. So one thing, if you're starting this Roadrunner restaurant, it might make good sense, even if at the time you're not thinking about it, or even considering it, to really go out there and look to see what's out there within your city, state, the nation, and figure out where you're going to be able to operate. Okay, especially with our global economy. A restaurant's a little less global than other businesses, but a lot of businesses are easily transition to over state lines into other areas, right? Like for instance, with my business as an attorney, I currently work here in Arizona, but I'm working on getting licensed in Utah, and as soon as I'm licensed there, boom, I can start working there without moving there. Transitioning, my whole business model just shifts, right? It just changes. Now I'm including people in Utah, so it's good to make sure up front that that one, you're not going to infringe on anybody's trademarks, and also that you will be able to expand your market past where you are. So like I said, trademarks, you don't have to register them to have the right to protect and exclude others from using yours. But however, if you don't register it federally with the United States Patent and Trademark Office, you're going to be limited in scope to, of course, your industry, but also geography. All right, so you might be limited in scope to your town, to the immediate area around your town, or maybe your state. Wherever you've been practicing, wherever you've been using your name, you're kind of limited to have put those people on notice as to your exclusive use of this trademark. Okay, so if you want to, even if you're opening just one store, if you want to protect your name for any future growth, the best thing to do is to register your name federally. All right. And what that does for you is it puts the whole nation on notice that you are using this name in this industry as a restaurant or as a business coach. And no one else in the nation is going to be able to use that from that point forward in that industry, as long as you continue to keep that registration up to date, which means you continue to use the name in commerce. Like you don't put the business on hold. And also you file every 5 to 10 years, you have to file a renewal of the registration. As long as you stay on those deadlines, keep the registration alive, you're putting the whole nation on notice that you're using this name. And even though you're using it only exclusively in Tucson, Arizona right now, it doesn't matter. You have the right to exclude everybody throughout the nation from using your name because you've registered it federally. So when you do break into, open a shop in New Mexico where your mom lives and your brother wants to help you expand there, you can do that because you've got that registration in place. Now, so that requires a little bit of upfront diligence, meaning that you're going to do a bunch of searching up front or hire someone like an attorney to do the research for you and to get that trademark filed. I don't recommend you do trademark registrations yourself. There's a lot of nuances involved. I recommend that you do hire someone to help you with that. The investment is worth it because it's really, just think about it, 10 years down the line of building your business and you have to change the name or change the logo. That's a huge impact. That's a lot of money and a lot of time and effort, and to try to not cause confusion with your current customers and change your model. It's just, you're reordering stationery, you're reordering everything, right? So anyway, so that's something to think about, looking into doing a search up front and getting registered federally. And then from there, you're able to exclude everybody nationally. Now, not a problem, but it's something to think about when I said a registerable mark. For a mark to be afforded trademark protection, it has to meet a couple requirements. And those requirements are that the mark needs to be, has to be kind of distinguishable. It can't be general, right? Meaning that it can't be merely descriptive is the word I was looking for. So it can't just be a merely descriptive mark, which a lot of people use and end up using. It can't be like, Todd's Law Firm, that's not really, that's just describing the business. That's not really a trademark, right? So think about Apple computers. And when someone thinks of apples, let's think about, back in the 70s, if someone thought about apples, a computer would not come to mind, right?
Yeah.
When they started that business, a computer would not come to mind. All right. Even maybe for the first 10 years of that business, people would hear the word Apple, they wouldn't think computers, right? Now we do, of course, but an Apple does not describe a computer company. It just doesn't. So having a merely descriptive name is going to bar you from being able to protect that name. All right. So if your name just merely describes your business and the services you're providing, you don't have any recourse to exclude others from using that name. And there's some other technicalities like with like using geographic names and stuff in your as your business name is, like, Arizona this or things like that, to where it might not be distinguishable, might not be it might just fall under the merely descriptive or not qualify. And there's just a second, let me look at my notes here.
Now look at your notes because it's a lot.
Yeah, it's a lot here. So I brushed up on all 4 of these today. Let's so having a name that is, or a trademark, a mark that is unique is important. There's another word I'm trying to think of that is just escaping me right now.
So what I'm thinking is, while you're looking about that, is when Apple first came out, and people are not thinking about Apple the computers, but when they promote themselves, they have like that Apple logo where there was like rainbow colored, and then they were called Macintoshes, and then they kind of grew into Mac. I feel like the Macintosh and that logo was trademarkable because it was very distinct to whenever you saw it, and then you associated, Apple computers with that.
Yes, exactly. And you can, something that you kind of hinted on there is you can grow into the distinguishable part, right? To where you might have a descriptive name up front, merely descriptive name up front at first, and the trademark office is like, yeah, no. And you can ask them to, you get put on like this separate registry to where you're given time to build up a reputation around this business and around this name, and to prove to the trademark office that no, I have grown this brand. And even though the name sounds merely descriptive, now it's known for the quality, and the consumers, are understand and recognize that when they hear this name, they associate my business with it. So there is a way to build that up, even if you have chosen a name that's the office would consider merely descriptive. There's a way to build that up, and there's also a way to lose it, right? So you can lose your trademark. For instance, let's see, what's a good way to describe this? Like Kleenex, all right, in the US. Kleenex is or even, we'll use Band-Aid because people kind of understand this a little bit better. Okay, so Band-Aids, right? When people say Band-Aid, you just think about the thing you put on a cut, right? You're not necessarily thinking about the brand Band-Aid. And that's why if you look at Band-Aid on a box, it'll say like Band-Aid, the brand, right? Like that's part of the name, Band-Aid, the brand. So they're trademarking Band-Aid, the brand, because they've lost the name Band-Aid because it's become generalized in society.
Yeah.
Band-Aid doesn't just refer to the company. Like back in the day of inline skates, rollerblades was getting there, right? Everybody just referred to all inline skates as rollerblades. So you got to be careful. It's up to you to enforce your trademark, because you don't want it to become generalized. Like Google is, I don't think it cares so much, but it's on the verge of becoming, genericized, become a generic term for searching on the web. I Googled this, I Googled that. They're not necessarily, they're just saying you search the web. You could use Yahoo to Google these days, right?
Okay, yeah, but now that's been so common.
Yeah. So ways to get around that and to enforce your trademark is important. Like you got to stay on top of it. Now, here's a fun story, an example. Coca-Cola. All right. So the Coke brand, they have one of the most, them and Apple, arguably two of the most expensive brands out there as far as the valued brands, right?
Yeah.
That name Coke is worth a lot of money. That name Apple for computers is worth a lot of money. So Coke wants to protect that. All right. They don't want it to become generalized. And they have whole teams of employees, departments. I understand that. Again, law school story. So there's that. So like departments of people, like literally, like they go. It's this job. They go out and they go to fast food restaurants or a restaurant anywhere, and they will order, or a store, and they'll order a Coke. And then as they get that cup of cola, if the person didn't say anything, they just handed them the cup of cola, they take it back, they test it, and if it's not Coke, that restaurant or that store probably has a cease and desist and maybe a lawsuit on their hands for infringing on the trademark because they sold somebody else's product under the Coke name. That's why often you'll go and people don't know this is why this practice was put in place, but a lot of times the reason this practice was put in place by restaurants to clarify, well, we have RC Cola or we have Pepsi. Is that okay? A lot of people do it just because they want to make sure that people know what they're getting because they think the taste is different.
Yeah.
But also a big reason why the corporation wants them, the franchise owner wants them to be asking that question is to make sure they don't infringe on Coke's trademarks. So you have to maintain your trademarks and make sure that they don't become generalized if you get big enough, right? I mean, or if you're unique and have a unique industry that you create an industry that people start falling from and start kind of copying, not illegally, but on the fringe there. You start becoming competitors in that industry that you kind of started the trend with. that's another place where you want to watch and make sure that your name isn't generalized for that industry. So some things about it. It takes money, it takes time, but you can enforce those trademarks. And you need to make sure that you do. Again, there's no trademark police out there, so you need to be sending those cease and desist and lawsuits to maintain that trademark so you don't lose it.
I think we've given the audience a lot to think about, especially the difference between like copyrights and trademarks. Like my brain's like buzzing right now. I've studied this in the sense of my own research, but it's really lovely to have you kind of expand more about it. And hopefully a lot of us can do greater diligence in protecting our brands, and just knowing that my website can be copyrighted or is technically copyrighted with all the information on there. You kind of generally hear it, but to hear it from you and the examples has really, really been helpful.
Yep. Yeah, just the production and the appearance and everything. Those are, if they're new and unique, and yeah, they're yours. And make sure you do own them if someone else designed them for you.
Yeah. So check on your contracts and talk to your vendors before you start signing anything to make sure you're protected and own those things. So I think we've gone over a lot. I would love to break this up into a part 2 where we cover the other 2 parts of intellectual property, trade secrets. With me being in the restaurant industry, I've heard a lot about trade secrets. So I can't wait for us to chat over that. And what was the last part? I'm having
patents.
Patents, yes. So a lot of you are watching our service providers, but maybe you created a certain way to create an app, or how you create your products. A lot of you do make products. So this would be a great session to watch next time. Todd, did you want the audience to walk away with anything else when it comes to copyrights and trademarks?
Again, I really think this is somewhere where you are best off working with someone. These are important points. This is the lifeblood and the image of your business. It's what distinguishes you from your competitors more than anything. So, and helps you keep what is yours. So I recommend really getting spun up on these things, really getting a deep dive and find out what IP you have. You might still walk away thinking you don't have any, but you probably do. So find out what it is and how you can protect it. I just recommend that.
And I just want to reiterate with my accounting background that it is worth something. So it may not be a tangible physical thing, but it is recorded on your books as an asset, because like Todd said, you're making money off of this stuff. You're making money off your brand and these things. So you really want to start thinking about how to protect yourself. And even if you think you're just going to have this one thing now, maybe set yourself up for in 5 years or in 2 years, you decide to grow. So start thinking about the things that we talked about today. And if you have any questions, Todd, what's the best way to contact you for a great consultation?
So best way to reach me probably is, shoot me an email, Todd@StrategicLegalWorks, or you can find me on social media. You can find me on Facebook, either Todd Jarvis privately or Strategic Legal Works on my Facebook business page. It's really active. So, connect with me there, and I'll be sending out some more of this content and helping you guys really feel comfortable with the foundations in your business, because business takes risks, so you want to feel comfortable making and taking those risks to move forward. So yeah, reach out, let's talk and see where you're at and where you want to go.
Well, thank you so much again for today. We can't wait for the next part for this, for intellectual property. I will make sure to put Todd's contact information along with mine down in the description box, and links to all the other parts of the legal series. And if you had any aha moments, please share them in the comments. We would love to hear from you all. And if you do have any questions, feel free to drop them in the comments as well. I'll make sure that Todd gets tagged so he can answer those. And you guys have an amazing day.
All right. Thank you.